Hello, I am Craig Tingle of the Tingle Law Firm, and I want to thank you for tuning in and taking a few moments and allowing me to discuss with you contract formation in Florida. If you are tuning in to this period of instruction, you may have an issue regarding breach of contracts, concerns about the terms of a contract, or you may be wondering if a contract even exists in the first place. In Florida, there are 5 ways by which a contract can be deemed to exist. For those who have no formal understanding of contract formation, you may be under the impression that only one way exists, that being the written contract. Others may understand, often correctly so, that there are 3 ways to create a contract. However, I believe that after this instructional video, you will come to agree that there are indeed 5 ways for a contract to be deemed created. Those are the written contract, an oral contract, a contract by operation of the parties, a contract by quantum merit or equity, and a contract to prevent unjust enrichment. The written contract. This, of course, is the most obvious form of contract and the easiest for the parties and the court to decipher. When writing a contract, be sure to precisely spell out the terms of the agreement. At the beginning of most business relationships, things are usually going well. Written contracts are for when times are bad or there is a confusion between the parties. The contract agreement is the first place to go to address these problems. It should address all matters deemed essential for smooth functioning of the enterprise. Furthermore, one should include additional information to address non-performance, default, payment terms and procedures, as well as other recurring events. It should also address administrative and jurisdictional issues such as notice, venue, and whether prevailing party attorney's fees exist. I recommend hiring an attorney. The relatively small amount that you spend now may very well prevent you from having to spend tens of thousands of dollars down the road. Oral contracts. The next most common type of contract is the oral agreement. As the term implies, this exists when the parties make an agreement without a writing. These are valid contracts in Florida, and they are generally enforceable unless they are prevented by the statute of frauds. And those exceptions are best discussed at another period of instruction. To bolster an oral contract, one will usually need some sort of extrinsic or outside evidence. Oral contracts rarely, if ever, stand on their own. You will need witnesses to the agreement, payment, partial performance, or some other benchmark to demonstrate that a contract existed and that it was breached, and ultimately that damages have arisen because of that breach. Contracts by the operation of the parties. A third way that a contract can be created is by the operation of the parties. This is also known as an implied in fact contract. It considers that despite the lack of words, written or oral, that based upon the facts and the circumstances, a contract was created. For example, suppose there is a youth car wash and you pull in to get your car washed. You are a member of the community and familiar with this activity and how it is conducted. You see others paying $10 for cars to be washed, and you permit the young people to wash your car. Upon satisfactory completion of the car wash, you would owe $10. No words were exchanged, yet there was a bargain for exchange, and the magic words for a contract exist, which are offer, acceptance, and consideration. Despite the fact that no words were exchanged, there was an offer, there was acceptance, and then consideration would be owed. Quantum merit. If we stopped our discussion of contract formation here, we would be largely correct. This is because the parties to the contract create each of the previous contracts. With respect to quantum merit, the law creates the contract based upon one party having performed services when the parties must have understood and intended compensation to be paid. It is based upon the assent of the parties. This is often used where there is a technical deficiency in an existing contract, so the contract is said to be unenforceable or non-existent for legal purposes. For example, suppose you mow someone's lawn for $50. You mow the lawn each week for 2 years and you're promptly paid. There is a contract that says you will be paid $50 each time you mowed. Now the homeowner says, I never told you to mow each week and I'm not paying you. Quantum merit will be used to take the place of the contract, or even in the absence of any contract. In short, quantum merit is equity. Equity is, to say it another way, is to do the right thing. The next method, unjust enrichment. A fifth way for a contract to be deemed to have been created is by an equitable doctrine to prevent unjust enrichment. Unjust enrichment is not a contract theory at all, but it works like one. It is a quasi-contractual remedy and exists to impose an obligation by law to do justice even though it is clear that no promise was ever made or intended. Unjust enrichment arises out of society's interest in preventing the injustice of retaining a benefit for which no payment has been made to the provider. So you move into your new house. You are getting utilities from your energy cooperative and you continue to do so without getting a bill. Then a year later, you get not only a bill, but 12 months of back bills. You would be obligated to pay those back bills under the theory of unjust enrichment. At this point, I think it would be cumbersome to describe this process further, but I would invite you to contact my law firm if you would like to pursue representation via our law firm. To learn more, please contact me at Tingle & Associates PA at embarkmail.com or call us at 850-650-8138 or visit our website at www.tinglelawfirmdestin.com. I look forward to meeting with you.